Ladies and gentlemen of the jury, I thank you very much for your patience. I've tried to reason through this evidence, drawing the fair inferences as best we could, looking at the integrity of the evidence, and I just think there's very little question here, is there? So much of the essential facts in this case are just shot through with reasonable doubt. There is something wrong. There's something terribly wrong about this evidence. Somebody manufactured evidence in this case. There's missing blood. There's EDTA. There's questions, serious, deeply troubling questions. You must distrust it. You have to distrust it. You cannot render a verdict in this case of beyond a reasonable doubt on this kind of evidence. Because if you do, no one's safe. No one. The Constitution means nothing. This cannot, will not, shall not happen in this country with you good people. It just won't. Thank you very much.
Thank you, Mr. Scheck.
That was the legendary Barry Scheck giving his closing argument in the O.J. Simpson case back in September 1995, and many credit it with the acquittal of Simpson in that case. My name is David Oscar Markus, and it's my real pleasure to have Barry Scheck, the legendary, the titan, the wonderful criminal defense lawyer, coming on for the defense to talk about not just Simpson, but the Innocence Project and all the work he does for our bar, for innocent defendants, for all defendants, and for civil rights plaintiffs. I'm excited. I hope you are too. Let's get to it in For the Defense next. So we're here with the wonderful Barry Scheck. I'm really honored and pleased to have him on the show, and we're going to be talking about being a criminal defense lawyer, what it's like to fight for the innocent, and what it's like to be in the trenches. So welcome to the show, Barry.
Well, welcome. I thank you very much, David. And just your listeners should know, if they don't, that you just got an acquittal for Andrew Gillum, and that hung 10-2, you tell me, on the other counts. And the prosecution, just before we started, said they're going to dismiss them. So you deserve all the props and congratulations today.
Well, thank you. I mean, that case we tried out of town, and I see you've tried lots of cases out of town. I know you tried OJ out of town for 9 months, and people don't realize what it's like to be on the road as a trial lawyer. What was that like for you, being on the road, not just in the OJ case, but in other cases, just being traveling?
It's never great. The Simpson case, was a different reality. I mean, because I started as a public defender in the South Bronx in 1975, and after 2.5 years there, I went to the Benjamin N. Cardozo School of Law for its first graduating class and started a clinical program, right? And then taught everything else you could in the school of all different kinds, but all different courses, and put together a whole curriculum of a different sort. But believe it or not, for the Simpson case, I actually could try that case, and went out to Los Angeles over Christmas. Read all the materials, got to meet, the ever-changing team, eventually being led by Johnny, who became, a great friend and law partner on civil rights cases. Uh-huh. But I actually taught a whole semester at the law school of courses and just watched the trial on television. And it was all downloaded by Westlaw. so I could look at everything that happened. It was the most absurd, crazy experience.
Amazing. Presume you were able to do it long distance.
It was CNN and Court TV and all the rest of it were our Zoom links.
Right.
Instant transcript, daily copy. So that doesn't even count. But actually, the times that I did the most litigation out of town is that, I guess it's now over 20 years ago, Johnny Cochran, Peter Neufeld, and I started a civil rights law firm. And, Johnny was always doing civil rights stuff, but Peter and I had never really thought about doing it per se. But, Johnny moved to New York after the Simpson case, and we wound up being asked to assist the representation of Abner Louima, which was a case that, blew the roof off New York City because he was a Haitian man who was literally framed by cops, brought to a precinct in Brooklyn, and they sexually assaulted him with essentially a broomstick up his rectum. And it just blew the roof off the city. And actually resurrected, he'll be the first to tell you, the Reverend Al Sharpton is a leader of that. So, once we did that case and then wound up, suing the police union, getting, all kinds of non-economic relief from them and from the city of New York, and that took years. But then after that, we began doing a select number of civil rights cases, some arising from wrongful convictions, and that's when I really went out of town to try cases.
It's a big tax it's taxing on you and the family when you have to travel like that.
Horrendous. It's very difficult.
Right. Let me ask you about the civil rights stuff, because I always found it interesting. I only do criminal, and I'm always scared to go over to the civil side and do civil cases. Do the skills translate over easily, or was it a whole new world going over to the civil side?
They translate so easily, it's ridiculous. Because just envision this. I couldn't believe I started taking depositions.
Right.
And, you ask a question and the other side says objection, and you say answer. That's it. And as long as you play by the rules, it's extraordinary. And you don't, and the advantage that a criminal trial lawyer has doing civil work is that you spend a lot of time planning the crosses, or the adverse. They become the adverse witness when you're the plaintiff in a civil case, but you plan a lot of the crosses the way criminal defense lawyers would, and that is you have a plan for how you're going to get to the witness, the information that you have to impeach the witness, and you have a plan to maximize the chance of getting the answer you want, and you sequence everything like that. And what I found, because I've done over the years a lot of teaching of trial practice, I did all the NITA stuff and the National Criminal Defense College and a lot of that over the years. But for a while, I even got paid, believe it or not, to teach associates at major law firms how to try cases. And what was strange to me is that, I'm like at Paul Weiss Rifkin, and I'm looking around at all these, legendary trial lawyers, and I'm telling them how to do depositions, because as a criminal defense lawyer, you have insights into this that a lot of them don't.
Right.
And it turns out to be, remarkable. I mean, I've taught clinical education, clinics, which I think in some ways is, the most enriching and deepest experience. When I started teaching clinics, it was the beginning of the clinical education movement. Mm-hmm. And, we learned from people like Tony Amsterdam and a whole group of guy up in, it was the early clinicians had really thought this through. And the idea is that you want students to know everything about uh, uh, reading cases, precedent, how to understand, the basic case law and reason about it, right? What we teach you in the first year or two of law school.
Right.
Then clinics are more important in a way because you have to do fact gathering. You have to teach interviewing skills.
Yeah.
You have to, in my mind, do problem solving and look at institutions, figure out how to change them. So I was extremely lucky to be among the first to start doing clinical education in the legal academy. And, some people did only small cases, supervising the students. We did that, but we also did what we call major litigation projects. And the major litigation projects were, big criminal cases,
right,
homicide cases, federal appointments. And then we would do interesting cases involving science. And at the very beginning in like 1989, 88, 89, I did with my colleague Peter Neufeld, we did some of the early DNA cases.
Yeah, I want to talk to you about those DNA cases. I want to talk to you about how that got started. And actually, you started the Innocence Project back when, in the early 90s?
1992, but we litigated the admissibility of DNA testing in like 1988, 1989. And what happened, it's quite extraordinary and very lucky people, that we understood that this was going to be transformative, right? And became very interested in it and got appointed by the first Governor Cuomo to some committees to actually think about the transfer of this technology being used for research and medical purposes to the forensic arena. And that transfer of technology, nobody should have assumed that would be easy or it wouldn't create its own challenges. And what we discovered right away is that there were a number of companies that were trying to win market share by making their DNA technology the one to use, right? Both for public labs and private litigants. And they were putting out papers and, advertising that they could do this before they had even done, really proper validation. So we first got involved with our old public defender's office, where somebody came to us and said, "Oh, you're very interested in this," because we held the first academic conference on DNA in the criminal legal system. And they said, "I have a case of a guy named Castro," and the prosecutor wanted to say blood on the watch that he was wearing came from the victim, but it didn't come from him. So we just did the admissibility hearing, right? And the Fry hearing in New York.
Right.
We did it in front of Judge Judy's husband, Jerry Scheinlin, right? And it's quite extraordinary to think about. So we wound up reaching out to all, these great experts, because we thankfully knew something about conventional serology, but we began meeting all these geneticists who were in their 30s, right? And early 40s, who were in the labs that were mapping the human genome.
Amazing.
And so we went to a conference and we met this fellow, Eric Lander, who, had become President Biden's science advisor, first time a cabinet position, who led the public group that mapped the human genome. But when we first met him, that was all in progress. And we met him at a conference and we showed them the autorads and everything that the prosecution in the Bronx wanted to use in this Castro case. And he took a look at them and he said, "This is ridiculous."
Right.
And we brought in a whole group of witnesses. And the other side already had signed up Nobel Prize winners, because they naturally assumed all this was going to work. Is understandable. And we showed that they hadn't figured out the ways. First of all, was when they used that testing RFLP with the bands. People remember that from the Simpson days and other times. But they couldn't even they hadn't validated a matching rule for these restriction fragment length polymorphisms, and they had no idea how to do the kind of validation one needed to tell us anything about the population genetics, about the probative value of any association that you could get, right? And so, we at this hearing, we put on all this evidence, exposed all the problems.
Right.
And the prosecution witnesses recanted in the middle of the hearing.
Oh my gosh.
The hearing took 9 months, but we were bringing in people from everywhere. But they recanted, and I remember Dr. Lander he wanted an Apple computer, and he got all the scientists together, and they wrote a joint statement saying that the prosecution's, evidence to associate the defendant with, saying the blood on the watch came from the victim, that the matching rule was wrong, the population genetics were wrong, and that the National Academy of Science ought to form a group to study the transfer of this technology from medical and research purposes to the forensic arena. And that's exactly what happened. From that hearing, it went to an article that Eric Lander wrote for Nature, to the National Research Council appointing the first of a number of committees on DNA testing. So, that was a major litigation project.
Right.
And we recognized immediately that this would be a big deal. And we knew that there were problems with using it to say this blood, this biology came from that person. On the other hand, exclusions were pretty easy, right? There was not much dispute about it if, the bands are really different. And so we recognized immediately that this was going to be a big deal. And one of the people that really helped us was Janet Reno.
Amazing.
Your friend Bill Tersch was working for Janet Reno in those old days, but Janet immediately commissioned a book, Convicted by Juries, Exonerated by Science, the study of like the first 36 of them. And we wrote a foreword to that. And she immediately established a commission on the future of DNA evidence with the National Institute of Justice.
She was a progressive prosecutor before there were progressive prosecutors.
Yeah, she was great.
She was great.
And when we became an independent, we developed an independent nonprofit at the Innocence Project, still affiliated with Cardozo Law School. Janet was on our first board. So
it's amazing, Barry. You and Peter are you started this project however many years ago it was, and now
1992. So
and now there are innocence clinics at law schools throughout the country. There are innocence projects in every state. It's you guys are heroes to so many people and are doing such good work. One of the things that still strikes me about it is that prosecutors don't embrace it. You would think they would want these results. They wouldn't want an innocent person in jail. And yet in so many cases that I read about, they say the prosecutors object to the testing. The prosecutors object to the person coming back to court. It still really bothers me. I don't even understand it.
Yeah, well, of course. And you're right to be puzzled by people that would not want to know if an innocent person had been convicted and didn't seem too concerned about the fact that the guilty party got away free to commit more crimes. But one of the things that happened right away, and shows you how smart Janet Reno was, that when we started this commission on the future of DNA evidence,
right,
one of the first things that happened is that we formed the subcommittee that wrote a book on recommendations for DNA testing, right? And it was designing ahead of time best practices, right? And we looked at all the different stakeholders. Here's the best practice if you're a prosecutor. And we said, look, here's category 1, category 2. These are cases where even though the law allows you to say, I'm not going to allow you to come in and ask for a DNA test because the statute of limitations ran years ago, right? You should consent because it's a single perpetrator rape case.
Right.
Or it's an obvious one. So category 1, category 2 cases, you consent. Maybe there's a category 3, maybe it's anybody's guess. 4 and 5, you don't have to consent. And those were recommendations for prosecutors. But then there were recommendations for crime labs, recommendations for victim services agencies to talk to the people that were harmed by crimes whose cases were now subject to DNA testing that could be a different result, recommendations for defendants, recommendations for defense lawyers. We really covered the waterfront with that. And, I had been very focused personally just on let's pass a statute, right? Because when we started in 1992, there were only 2 states that had a post-conviction DNA statute, New York and Illinois. And that was not an accident that
Right.
those have been passed. But eventually we had a model statute, and eventually there were other guidelines that came out of that commission. But, that was, so we changed a lot of minds, right? Interestingly, so that helped us. So even in jurisdictions where prosecutors were being very foolish in not wanting to find the truth, right? We got more consents than you ever would have believed.
Huh.
So it's in retrospect, it's quite something. And now the network, we have 71 innocence organizations within our network.
Amazing.
In the United States and 13 abroad. It's become an international human rights movement. And many of those innocence organizations within the United States, obviously they started in law schools. And that was by a conscious design, because we began teaching courses, wrongful convictions, causes, and remedies. Because from the beginning, it was not just about exonerating people. It was by doing a deep dive academically into what are the factors that bring about wrongful convictions, right? Teach everybody how to use DNA and to start thinking about it. But what about eyewitness misidentification and false confessions and junk forensic science and bad forensic science, prosecutorial misconduct, police misconduct,
Right.
Bad lawyers, and of course, the worst of all was the intractable problem of race, the original sin.
Right.
So we had this whole course that was by 2000, when we began really launching the network, that any law professor could say, okay, I've got a 3-credit course. It's all, you have video lectures, race. We found this young man to talk about race nobody had ever heard of, named Brian Stevenson. Steve Bright talking about indigent defense. I mean, we had, Gary Wells did eyewitness identification, you name it. We had the leading experts. So you could say to your law school, here is a 3-credit course. And we did everything on Westlaw, right? We had 4 video conference hookups. Did hiccup, it was very bad.
Yeah.
But we did those lectures in an hour and a half. And Sam Giberson, who you might have dealt with over the years, who was an NACDL person who did a lot of technology, he came and he videotaped them all for nothing. Amazing. And we took the videotapes. We would tape on Thursday, he'd send them out on Friday, and by Monday of the next week, you had a lecture and a course. And we went through the NACDL book, and we said to each of these professors in law schools, here are the best criminal defense lawyers in your jurisdiction. Call them up, and they'll help you get innocent people out of jail. So all your friends, probably most of the people you've interviewed on this podcast, did it.
So it's funny because, that's what I'm trying to do with this podcast is talk to trial lawyers and try to get back out there the art of trying cases and how important it is to be trying cases, and to speak with folks like you who have tried such important and big cases. because the trial is dying, and it's really too bad, because I think what happens is innocent people are pleading guilty. One of your judges in New York, who we had on the podcast, Jed Rakoff, talked about the problem with innocent folks pleading guilty, and there are so many reasons for it. I mean, you talk about in civil cases, just getting depositions. We don't get depositions in criminal cases. That alone, I think, would help.
No, wait a second, David. You're practicing in Florida.
Well, we do get depots here in state court in Florida.
No, I mean, what about the rest of us? We're just getting discovery room. I couldn't believe you get depositions. By the way, Missouri gets them too, but they don't take advantage of them.
Yeah, I'm surprised DeSantis hasn't gotten rid of depots here yet. He just passed a new statute saying the death penalty can be imposed here in Florida with a vote of 8 as opposed to 12. It's nuts. So who knows how much longer we'll have depots.
Well, yeah, but I have a strong recommendation for you. All right. I mean, one of the interesting things about Florida is that you've had these open records laws, right?
That's right.
And so that has really made a gigantic difference. And we're just catching up to it in the rest of the country. You've had access, if you've wanted it, to files from police departments where they make adjudications, and I think even unsubstantiated, as unfounded allegations of misconduct. And one of the main things I'd like to see in Florida is that we have projects going on across the country, and when I say we, I mean innocence organizations, the ACLU, journalism schools, progressive people who want criminal legal reform. Trying to create databases of this misconduct information. So the next frontier, which Florida is uniquely situated to pursue, is to get all of this data, right, and create databases. So the vision that I have, I wrote something about this in some law review articles, but we're doing it in different jurisdictions, is that in every jurisdiction, major jurisdiction, you will want to have a public-facing database. The most famous model is the one in Illinois, in Chicago, from the Invisible Institute, which is a journalistic enterprise started by Jamie Calvin and others, where you go to the Citizens Police database, and you can't believe what you see.
Amazing.
It's all these cops. And they got everything, by the way, because of a case called Calvin versus the city of Chicago. They won it under case law, what you've had it by statute for years. But then they began gathering all the information. So then the Legal Aid Society in New York started creating applications they could use on cell phones to track the misconduct information. So each lawyer could come into court and you'd see who arrested the client, right? Which cop. And then you would immediately get, all the information about the police officer. And then you can begin to track this information in terms of what are the patterns of constitutional violations in a particular jurisdiction. And it's not just one officer that gets tagged for the misconduct or violated, the Fourth Amendment or however other amendments and committed acts of misconduct. But what about that person's supervisors, right? And so you should be able to create a really incredible database in Florida, and you have the rights and the ability to go after those police officers, and make sure that they essentially get decertified or lose their licenses. So
we need to start to start the Brady Project in association with the Innocence Project.
Well, the Brady Project is, in my view, what we call conviction integrity units, which we have.
That's right.
We're quite responsible for getting them started. I'm not swearing behind all of them, but it's a good theory, good institution to have. But prosecutors, as you mentioned at the very beginning, they should be as concerned as defense lawyers.
But they're not. But they want to win. So it always bothers me how much they care about winning over sort of doing the right thing. And I think the problem is, one of the things that we're talking about is they view the truth as, did the person do it or not? Criminal defense lawyers are often worried about, the process truth, right? So what did the cops lie? Did the cops plant evidence? Did the cops do bad things? And so there's this fight, this tension about, did the person do it versus sort of, was the process okay? And one of the things I like to talk about with young lawyers is, it's so important because I don't think jurors appreciate a bad process. They still are focused on, are these people lying to us? Are these people doing the right thing? And if they believe there's a cover up, if they believe the cops are lying, they will vote to acquit.
Yeah, well, I think juries will do that. And but the one thing I would say is that we have to, I'm a law professor, right? So I've trained, generations of people, to practice law and to do trials and to think about, forensic science and ethical rules, and ethical rules civilly and criminally. And in my view, I think prosecutors, there are prosecutors, we have to train them. They have to care as much about, following the rules and getting the truth out. They should take as much or more pride in correcting an injustice as they do in getting a conviction. Because, what we learn very quickly on the defense side is you have to be humble. You think you know, but you don't really know.
Right. Right.
We have trials. And if they took that seriously, and I think many do, and we train them to do that, and it becomes different. And so one of the things I should point out is that when we began working, frankly, it was with the Dallas District Attorney's Office was the first time it really happened. That's when an African-American criminal defense lawyer shocked the world by being elected district attorney in Dallas in 2007, Craig Watkins. And then he started this conviction integrity process, bringing in defense lawyers and people from the Texas Innocence Project and the National Innocence Project. And we just started doing all this DNA testing in old cases and looking at them and basically established a set of informal rules that we've now codified. And when you start thinking about the post-conviction space, right? In other words, the case is now over. And yes, there's an adversary system. And yes, as you described, people get into tunnel vision and both sides really want to win, right? Yeah. And that really distracts everybody sometimes from plain problems with the evidence that we all should be concerned about. But when you get to the post-conviction space, that shouldn't be true. Right. So we pass some ethical rules, and Bruce Green and Ellen Yarashevsky get great credit for this. That kind of came out of the Innocence work. 3.8 G and H of the ABA rules, but there are different numbers in other jurisdictions, and that is, in a post-conviction setting, if a prosecutor knows of information that is material evidence of innocence, right, then they have to disclose it, even post-conviction, when the case is over. And if they know clear and convincing evidence of innocence, they've got to do something about it. Yeah, and once you envision it that way, it justifies our recommendations that you should have a conviction integrity unit that follows those ethical rules and that is the CIU, a person who runs the CIU should be a person that has experience doing defense work, because cognitive bias is such a strong factor, right? That lots of people that have spent all their years doing nothing but prosecution, it's very hard for them to wrap their minds around. But they don't look evidence the same way a defense lawyer would. So you should have a defender there, and they should report directly to the district attorney or the district attorney's counsel, right? Because it shouldn't be other people in the office that had something to do with that conviction that can weigh in on it. They should just be witnesses. And so we have a whole bunch of best practices like that. And across the country, progressive district attorneys have been elected. You don't have to be a progressive to believe in this kind of process. And they put units together. And I'm not saying they're all good, they're not. But if you follow this kind of process on the back end, right, you get to justice, and you learn a hell of a lot about the cases. So, by the way, I should jump right ahead and just tell you, we're talking about civil and criminal, right? You know, we literally got hundreds of people out of prison who didn't commit the crimes, but we never really figured out what happened until we sued them. As opposed to everybody.
So wonderful.
It's so different. And that's the kind of stuff, by the way, get right back to Florida, where I suppose more people listen to you from Florida than anywhere else.
I think that's right.
Okay.
Yep.
So what you should be able to pull together with the defenders and the ACLU and different and press, right? Poynter Institute, Tampa Bay Times, a lot of good press people in your state, and with the Civil Rights Bar. You have an unprecedented opportunity to not just look at, not just create a database of cases where we know convictions have been vacated, right? But you should go back and look at the civil cases that were brought after that, right?
Right.
And then the database can have all of that information in it, right? And you can commonly code and tag that information. And the reason that you can do it now in the ways we never have done before is that it is a different world. We are in the world of Chat GPT-4. We are the ability to do data mining, right? And to dive into this data. There are definitely dangers, but the ability to do that as never before can really change the system. And we have to be the ones to get this done first.
So important and so true. So let me take you back to your PD days for a second, when you were learning to try cases, and now you teach it, of course. When I first graduated law school, my buddy Milton Hirsch gave me the Herbert Stern books to read to become a great trial lawyer, and I gobbled those up. And now I love to read old trial books. What do you recommend for your students, and what did you look at when you were first a PD to learn the craft?
Well, it's interesting. I had read a lot of biography of it. This is sort of fun, but it's interesting. Earl Rogers from Los Angeles, a really great trial lawyer. His daughter, Adela Rogers St. John, has wrote a really interesting biography of him. And since I did go to law school in California, and I would, Berkeley Law School, but I would go sometimes to Los Angeles and I'd read the transcripts of his trials. Then in terms of, look, I was a clinical teacher, so I was reading a lot about, trial practice and doing, training in all the NIDA methods and other things. But there was a wonderful book that we all started with called The Lawyering Process by Gary Bello. The late Gary Bello, who was a great leader at the beginning of this. He died much too young up at Harvard. And that book had a skills dimension and an ethical dimension for every skill in terms of the lawyering process. Excuse me, that's a great book.
Did Lee Bailey make you read his books during Simpson, or he was, what did he do?
Well, listen, when I was in high school, my father managed a singer named Connie Francis. And F. Lee Bailey was dating or wanted to date Connie Francis. So at the height of his fame, when he was trying, some of these big cases in New Jersey when he was starting out, he had to take an interview from a high school newspaper editor, right? So I interviewed F. Lee Bailey about all his big cases as a junior or senior in high school.
Amazing.
And I walked out of the hotel room, and then Nat Hentoff walked in to interview him for Playboy.
That's great.
So, at one point in the middle of the Simpson trial, I showed Lee this interview, and I think his mother liked it, but it was ironic.
That's really funny. I interviewed him for this podcast shortly before he died, which he was still wonderful and on top of things. And what a character.
He wrote a great book. His book, For the Defense, was a great book.
Really good. Really, really good. So, that trial obviously was televised, and I know lots of people have strong opinions because of OJ about whether trials should be televised. I always think federal court should be more open, especially the Supreme Court. What are your thoughts about whether we should have these things televised or not?
Well, I've gone back and forth on that issue. I did a case before the Simpson case, years before the Simpson case, as a clinical professor. I represented a woman named Hedda Nussbaum, and she was indicted with her live-in batterer companion, Joel Steinberg, a lawyer, although I think he wasn't really barred, who illegally adopted a child, and they were living in Greenwich Village down the block from our law school. And one day, poor Lisa Steinberg was brought into the hospital because he had battered her. She died from those injuries. And they went into the home and they found Hedda Nussbaum, who had been a drop-dead gorgeous book editor from Random House. And by the time she, was taken out of Joel's apartment, the two of them, she looked horrible. She had a ruptured spleen. Her face was a mess. She was battered. She was aged. Her hair had turned gray. It was horrible. They were both smoking crack cocaine and in some kind of a delusional system. And I wound up representing her because I had been representing battered women's with my friend Michael Dowd and others.
Sure. And
so we began representing Hedda. And that case, we actually got the prosecutors to agree. It's amazing to think about. That she was not guilty by reason of insanity.
Wow.
She could never be a witness. And the reason is that the prosecutors, including my friend and a really amazing prosecutor, a great person named Peter Casolaro, we were all young parents, right? Mm-hmm. And we interviewed all these witnesses and we said, oh my God, we can see what happened here. This is horrendous, right? Mm-hmm. So we put her in a Four Winds drug facility, and she actually was able finally to testify and did. But all of this had wall-to-wall publicity all over the United States and around the world. If you can imagine, in New York City, all three networks televised the trial. Amazing. Instead of regular daytime programming.
Amazing.
So now, but that, prior to that, I had really been a traditional civil libertarian, and I was in favor of cameras in the courtroom. Right. And then after that trial, when I saw its effects on witnesses and on the proceedings, right, I changed my mind and felt that it should only be done with the consent of both sides. And I think some ways I was part of a whole group after the Simpson case, maybe a book on how to handle high-profile trials that had a lot of great recommendations. But I still pretty much take that view. A friend of mine from college, Steve Brill, who's a great journalist, a legal journalist, he invented Court TV.
Court TV, right.
And when we started Court TV, I was like a guinea pig,
right.
We did the rules. We had rules, right? Cynthia McFadden and Terry Moran. We had anchors that really knew everything.
Right.
You walked into Court TV, you had a briefing book, you knew what the jury instructions were, you knew the issues in the case, you had to familiarize yourself with the prior day's proceedings.
Not so much anymore.
Oh my God! And,
right.
and we developed Elizabeth Semmel and myself and somebody. We wrote ethical rules for legal commentators. Yeah. Because when it becomes an industry for ratings and people that get on television and they start saying things that they don't know what they're talking about, believe me, and I'm sure you've had this experience, David, right? That changes the case. That makes a trouble for everyone.
I mean, this Gillum case that we were in was in federal court, so there was obviously no cameras, but there was a lot of local coverage about it. And we would leave the day thinking, wow, we just kicked the government's ass. Like, we just exposed this witness. And then we'd read the articles and we were wondering how is this possible that they're writing about this one line as opposed to.
You're talking about writing. What's even worse when they're televised,
right?
That they take the snippets of the witness's testimony, and they'll always take the moment of maximum conflict, because if it bleeds, it leads.
Right.
And that was not the most important moment in the witness's testimony.
That's right.
So I have learned years ago that anything I read, or even if it's on televised trial, right? If you're not in the courtroom, you really don't know what's happening.
It's true. It's so true, because we were wondering, are these people watching the same trial that we're involved in?
Absolutely.
But that being said, I'm still a fan of things being televised, and I'll tell you why. In preparing for this, I went back and watched your closing for OJ. I wouldn't have been able to do that had it not been televised. I thought it was so cool. I'm watching the closing from 1997 or 98, whatever it was, as opposed to reading the cold transcripts. And you can get a lot out of seeing it. I saw from the beginning of your closing when Marcia Clark objected, and I don't know if you remember this, how upset you were at the beginning, and you guys went sidebar, and I guess Ito let you continue arguing about the integrity of the system that she was objecting to. But it was fascinating to watch that, which you would not have gotten from a cold transcript.
Well, the other thing, though, is that I think appellate arguments should all be televised.
Yes.
There's very little excuse for not doing that, subject to protective orders and things like that.
Right.
No question about that. But I think there are still some difficulties with televising trials. And it doesn't matter. It's not a question of even national publicity, as you just pointed out in the Gillum case. Local publicity is enough, right? And that can even be more potentially prejudicial to all parties.
Right.
So it's especially in an era of social media, and it's crazy. I mean, there are trade-offs. People see it on television. Witnesses do come forward that wouldn't have known that the case is being tried. That certainly happened to me. But look, I've been through a bunch of these.
Yeah, I'd say so.
I still think the best thing is both sides should consent.
So one last area before I let you go, Barry, and that is, you mentioned earlier the NACDL, which you were the former president of, and a lot of young lawyers who want to become criminal defense lawyers listen to this. Should they get active in NACDL? How do they become exposed? I always tell people NACDL is great because you can meet all the greats and all the great, wonderful criminal defense lawyers out there, and you were the actual president of the organization. So here's a pitch for NACDL.
Oh, well, I was actually, ironically, I was the only person who was ever president 2 years, because my predecessor.
Are you crazy?
They died. But when you say you're president, it's a leadership track. So you have to serve on all these offices.
Yeah.
And then after you're president, you continue. And I'm now still on the board of trustees. And I've never left NACDL, and it's a great organization. The most important thing, though, is that, yes, you can learn from the best. You get great continuing legal education, but there is no substitute for talking to people like yourself, who are gifted trial lawyers who are in the trenches, right? That's how you really learn what's up, to be honest.
Right.
And I think we are much better if we work together than if we work alone. There's no question. I mean, the NACDL and the Innocence Network and the American Bar Association and all kinds of terrific organizations, National Association of Public Defenders, we all have to work in unity. Impacted community groups will never change this system unless we all learn to work together, share information, and treat each other with love and respect, and that includes people that prosecute.
We'll even include the prosecutors. It's okay. We'll include them too.
And look, I bring a lot of bar complaints against prosecutors.
Yeah.
I believe that we all have to be held responsible, and one of the biggest problems not only is the standard for ineffective assistance of counsel, as Judge Marshall pointed out, dissenting in Strickland. It's terrible that the standard has to do with essentially the lowest common denominator.
Right.
What's a reasonable standard in your jurisdiction, right? We need objective rules if we're going to change anything. And then on the other side, this whole notion of absolute immunity for prosecutors at the trial phase, that's not in the Constitution. That's a made-up rule of the Supreme Court, and they should only have qualified immunity, or at the very least, we have at least one statute passed in California, and should be other jurisdictions, that if you're a prosecutor and you engage in deliberate and intentional conduct that leads to the conviction of an innocent person on a felony case, you should be subject to criminal charges.
100%. 1,000%. And that's the only way the system is going to change. Right. Well, listen, Barry, thank you so much for being on the show. But more importantly, thank you for everything that you do for the criminal defense bar and for the Innocence Project and the innocent folks out there. Seriously, all of us look up to you and we appreciate you. So thank you.
Well, thank you, David, and congratulations on your acquittal, right?
Thank you.
That's what keeps us going.
Yes, sir. Yes,
and
sir.
Let's make sure that we get some of this police misconduct databases going in the state of Florida. That'll be revolutionary.
I really could have spoken with Barry for the next 5 hours. I mean, the stories he has, the trials he's done, the experiences in the criminal defense bar, and the progress he's made for our bar and our clients. So I just want to thank Barry for doing it. And, that's the real point of the podcast, is telling these stories from the legends and getting them out there, because, so much is made from prosecutors and prosecuting people and putting people in jail and law enforcement. I think it's the best stories to tell from the other side, from our defense practitioners, from our criminal defense lawyers. So I hope you're enjoying it. We'll have some more coming up in the next couple of weeks. That was Barry Scheck. My name is David Oscar Markus, and that's For the Defense. Thank you.